Hello and welcome to Other Voices, brought to you by Peninsula Peace and Justice Center. I'm your host, Paul George. On this month's edition of Other Voices, we're going to examine in depth a recent speech given by President Obama. And I am not talking about last week's State of the Union address. More importantly, I'm talking about the speech that he gave on January 17th on the National Security Agency's domestic spying, global spying, all the digital data collection that's been going on. The fact that he gave the speech, I think, is encouraging to those of us as grassroots activists because he was responding to public pressure. But what did he say? What didn't he say? And what maybe he should have been saying is part of what we're going to be taking a look at today. Joining us to help us understand this rather complex and increasingly complex situation is Hanni Fakhoury, a staff attorney with the Electronic Frontier Foundation, one of the leading organizations working on behalf of our electronic privacy. Hanni, welcome to Other Voices. Glad to have you here.
Thank you very much for having me.
Let me just tell folks a little bit more about you. Hanni focuses on criminal law, privacy and free speech, litigation, and advocacy. He's written numerous amicus briefs in state and federal courts, and his writings have been published in the New York Times, Wired, Slate, and Juris magazines. Before joining EFF, Hanni worked as a federal public defender in San Diego. He's a graduate of the University of California, Berkeley, with a degree in political science and an honors degree in history, and he got his law degree with distinction from the Pacific McGeorge School of Law. One of my best friends is an alumnus of
All right.
McGeorge.
Go Tigers.
So to get us started, just tell us briefly what EFF does. I was stunned when I've known EFF for a long time, but I reviewed the website today. 1990 it was founded?
Yeah, we're approaching our 24 years now.
Yeah.
But basically what EFF is we're a nonprofit civil liberties organization that really works to ensure that our constitutional protections make it online with us and survive in an age of increasing technology and some of the challenges that poses. So we do a whole host of things. We do work in the intellectual property space. We do a lot of work on privacy issues, how to preserve our right to be free from unreasonable searches and seizures.
I've heard
online.
that phrase.
Right, yeah, it's an important, one of our most important pieces of our Bill of Rights.
I suspect we'll be talking about that at some point.
You can imagine. And it was specifically with respect to some of the NSA surveillance scandal that we've heard so much about in the news. EFF has been at the forefront of challenging a lot of these practices. There's been a lot of attention recently about the surveillance practices and programs that have been revealed by Edward Snowden since the summer of 2013. But if you go look at what EFF has done in challenging the NSA's ability to engage in warrantless surveillance against people here in the United States, our work has gone back as far as 2006, 2007, when we sued the NSA over warrantless wiretapping that was being conducted under the Bush administration. So we've been a big fighter and a big believer in ensuring that people's constitutional rights and their right to privacy and free expression remain alive and vibrant today.
Yeah, and an excellent advocacy organization you are on behalf of all of us. We'll be putting the website up on your screens. For those of you here in the studio audience, it's easy, EFF.org. Check it out, there's good material there. Before we get actually into the speech, I wanted to talk about an article that came out. It was all over the place. I saw it in Wired magazine online yesterday. Headline, in just 6 months, the NSA spied on more than 59,000 accounts. So the background of this is, as part of the pushback against what was revealed by Edward Snowden, the really big tech companies like Facebook and Google have been wanting to release publicly a lot more information than they've been allowed to about what they're being ordered to hand over to the NSA, the FBI, and all of that. So briefly on this, what's this mean to us? This is the Silicon Valley companies that we drive by every day, the companies that we use every day online, and they got tens of thousands of national security letters and subpoenas to hand over data. on a total of 59,000 accounts, and that only covers the first half of 2013.
Right, absolutely. And you know, the background, some of the background to this, because I think it's important, is to understand and recognize that for many years, the federal government has basically told the companies that they can't release this
Right.
type of information. And the information...
And that's part of the Patriot Act, right?
Yes, absolutely. And part of the Patriot Act and the subsequent reauthorizations of the Patriot Act have included what are known as kind of a gag provision that basically says that when a company like Google or Facebook receives a request for information from the federal government,
public library.
right, receives a request from law enforcement or from the NSA to turn over certain types of information about its users, the companies are supposed to basically not say anything about it. And since the Snowden disclosures, there's been a pushback from some of these companies to be more transparent to their users about the number of requests that they've received. And ultimately, in the last few weeks, the companies have reached an agreement with the federal government where the federal government agreed, to say that agreed to allow the companies to say that they received X number of requests over a given period of time. Now, to be clear, the X number that they're allowed to reveal is not a specific number that
Right.
is like 5,455. It's that they received between 0 and 1,000 requests, or
Right.
between 1,000 and 2,000
Yeah,
requests.
it's
So
in 1,000 increments. So
exactly,
you
and so
don't know.
so it's hard to tell the specific exact number of how many requests are received, and we don't even fully know the breakdown of those requests, whether they're national security letters, a FISA warrant, a traditional subpoena, or a FISA subpoena. But ultimately, it shows that the number of user accounts being touched by these programs, as you mentioned, in just the first half of 2013, was 59,000 user accounts, which is a significant number when you really think about just, these are accounts that are supposed to have some sort of connection or nexus to national security threats.
Right. That's a lot of threats, or
Absolutely.
what they think are a lot of threats. Do you find the number credible that there are 59,000? Now, some of these people, they say some of these numbers are high because people have multiple accounts. Gmail is free, so you
Sure.
can set up, anybody could have, 10 accounts or something. Do you find it credible that there are, say, 25,000 potential threats to our national security out there?
Well, that's a really interesting and a difficult question to answer, because on the one hand, it seems like it's so grossly disproportionate to the events we hear about or the plots that are thwarted, and it just seems to defy common sense. On the other hand, we know that these are the number of requests that are being made. And so I think ultimately what it comes down to is, I think one of the big problems with this whole law surrounding the NSA is the government over time has taken a very expansive view as to what is perceived to be relevant for a national security investigation, to the point where now the number of requests are increasing because they're really pulling at finite connections to see that a person is connected with someone who's suspected of terrorist activity or being a national security threat. And that's really, I think, speaks to the larger problem, which is we've kind of watered down the threshold by which the government can get access to this information. And so instead of requiring a more specific, targeted, particularized, belief that a person has a real connection to someone who's, intending to harm this country, we've watered it down, and now we can get at people's associations and contacts and maybe people that they have incidental connections or incidental contact with in order to get at what the government calls the needle in the haystack. And I think that's part of where we've gone astray.
Yeah. Let's get into some of these details and go through some of the aspects, at least some of the highlights or lowlights, if you will, of President Obama's national security speech, again, back on January 17th. It was interesting that he delivered this during a weekday, during the morning. It wasn't the big media event that the State of the Union address
Sure.
is, but it probably is as impactful on society as the State of the Union, where he's laying out a legislative plan. So Electronic Frontier Foundation ran a scorecard. Just hold that up quickly. You're not going to be able to read it on TV anyway. And out of 12 areas with a possible score of 12, I take it a 1 is good, and 0 is bad. He ended up with a score of 3.5. So 3.5 out of 12 is
not very good.
Doesn't sound like a passing grade to me.
Well, it's not a passing grade.
Let's talk about some of the important parts of this anyway. The number 1 on your list is stop mass surveillance of digital communications, and that's the one that's got everybody's attention. So let's talk about, let's remind people what that is, the data that's being collected, what you wanted to hear him say, what he did say. And so this is the so-called phone metadata that you're talking about
Well,
here?
there are actually 3 different forms of what we've called kind of bulk collection of records, of digital records. So the first is what we've kind of talked about as the phone metadata collection program that's authorized under Section 215 of the Patriot Act. And what the phone records metadata collection program is basically the government gets a record from Verizon, which we know for sure, and presumably from other service providers as well, about basically the information about who you call and how you make your phone calls. So that would be, who you called, what time you called them, how long you talked for, that sort of information. It's not the content of the actual phone calls, it's all the information about the phone call.
Right.
So that's one of the collection
If you're on
programs.
a cell phone, they know where you were calling from?
That's something that's debatable. The government has claimed that they don't collect that information. We know that they ran a pilot program to determine whether they could collect that information.
They seem to be running a lot of pilot programs.
Well, and that's a real big part of the problem. But at least as far as we know, it's about really not necessarily the location, but rather kind of all the other details about who you call. So that's one of the main collection programs. There's a second collection program that's called 702 collection. That's under Section 702 of the FISA Amendments Act. And what that basically does is it allows the government to collect certain forms of internet communication records that are traveling and that are thought to involve a connection to someone who is abroad, outside of the United States. And then finally, there's another collection program that's authorized under Executive Order 12333, which is an order that governs the targeted collection of communication records by individuals outside of the United States. So when we were looking before the president's speech, when we were looking at what he was going to do in terms of stopping bulk collection, we were really thinking about all 3 of those bulk collection programs.
Right.
And in his speech, he talked about the phone metadata collection program specifically, but didn't really address the other 2 programs. And with respect to the phone metadata collection program, he did say that he was likely to stop the program. There's been a lot of criticism about the program, even from the independent groups assigned to kind of take a look at the program. That includes both the program that the group that the president appointed as an independent advisory group, as well as the Privacy and Civil Liberties Oversight Board, which is another independent group that's supposed to kind of take civil liberties thoughts into account when reviewing the programs. And both of these groups independently said that there's a real question about whether the phone metadata program is useful as a means to stopping terrorism or investigating threats to national security. And so President Obama has said that he's likely to re-examine and perhaps end that program.
So that's the question you just kind of posed there is really kind of at the heart of this issue. Does the government really need to be doing this kind of thing? And has it been effective? As far as I can see, they haven't been able to document or tell us about a single case of thwarting a potential attack or tracking somebody down through this, especially the metadata program. And that's the one that seems to have individual people most up in arms. They can understand it, and they don't like it.
Right. That is really the heart of the issue is it necessary to collect everyone in this room's records, everyone who's watching this, collect their phone records in order to find a few people who are trying to harm our country. Now, in justifying the program, the National Security Agency or Administration, the NSA, as well as the defenders of the program have said, well, we have used it in order to capture some people who are suspected of terrorist activity. And there's only one case they can really cite to and refer to that involved the use of the program. And it was a case out of San Diego, California, that involved some individuals who were suspected of funneling money to Al-Shabaab, which is a Somali terrorist organization. And that is the one reported instance in where the program was used to potentially investigate a national security threat. Even in that specific case, it's been of questionable use because the suspect there had already come to the attention of the FBI even before the Section 215 program or the phone metadata program was being used. And I think the other issue is that's really the only case and the only instance that's been publicly revealed to and have been thwarted as a result of the program. And to be fair, it didn't necessarily involve a violent action or a terrorist action occurring within the United States. It involved someone who is charged and ultimately convicted of providing material support to terrorists. But again, it goes back to the issue is, did they need to collect everybody's phone records in order to arrest these guys when they already had suspicion about that individual even before the program was put in place and being used?
Yeah. One of the things that gets overlooked here is that there's a whole long list of organizations that are listed as terrorist organizations by the federal government, and anybody supporting or being involved with those come under immediate suspicion. But not all those terrorist organizations that are on that list, like Al-Shabaab, are targeting the United States or U.S. citizens or have any desire. I mean, they're regional. They have disputes where they live, and they're not all little mini Al-Qaedas hoping to attack New York City. So how does the government justify collecting all this data of U.S. citizens to stop a Somali group?
Well, I think part of the problem is technology has advanced to the point now where it becomes so powerful and it becomes so useful to the government in the sense that they can now keep tabs on so many different people, and they can piece together and link together so many people and figure out their associations and who they interact with and who they communicate with. And anytime, this type of power exists, the technology enables this sort of thing, it becomes, I think, very easy for the government to want to use it and get their hands on it. And then also, I think, to use it in a way to justify why they're collecting this much data to begin with. And I think maybe that's what's happening here. And on the one hand, I can understand and I can appreciate that, for the men and women who are tasked with protecting our national security, that they would absolutely want a program like this. But the problem is when we have such a one-sided approach of looking at the issue, and when we discount completely the fact that on the other side of the equation are people who haven't done anything wrong, who aren't suspected of criminal behavior or terrorist activity, that the only way to justify using the program is to infringe on their privacy rights, that's where you start to have a real problem.
Yeah. All right. So that was one score, and so you gave him a 0.2 out of 1 point on that one. So I guess that was like a C grade. You have another category in here that you pointed out to me before the program that you thought was really important. Stop undermining internet security. Now, what do you mean by that? He got a 0 on that one.
Right.
And this is a little bigger question because it doesn't hit on actually collecting this data or where they're storing it or whatever. But this is more a question of what they're doing to the internet in general, right?
Absolutely, and I would actually argue it does speak to their ability to collect, and that's because what the Snowden disclosures have revealed is that as part of the government's attempts at counterterrorism, what they've done is they've really significantly placed all of us at security risk in exchange in order to have the ability to get access to data that they want. And they've done it in a couple different ways. So one way they've done it is they've, there was a report that they, basically convinced RSA, which is a major manufacturer of security tools, and I even think they're here in the Bay Area. I may be wrong about that, but basically worked with them to basically water down some of the encryption standards that we rely on to scramble pieces of data into an unreadable form so that they can't be intercepted. So for example, you go online to log into your bank to pay a bill, and you'll notice that there's a little lockbox on the left corner of your web browser, and that's because you're entering in the data, like your username and your password, in an encrypted format, meaning that your sensitive credentials are being sent in a scrambled, unreadable format so that if someone intercepts your internet transmissions, that they can't get access to this otherwise very sensitive information. And that's the process of encryption. And so it's been revealed that the NSA has worked to convince a company like RSA to adopt less robust encryption standards. There's been suggestions that they've been able to install what are called backdoors, meaning a way into certain forms of software in order to be able to extract information. It's been revealed that the NSA, in collaboration with foreign partners that also engage in surveillance, like the UK's surveillance organization, have been working together to basically find ways into material or data that's stored by Google abroad or
Right.
Yahoo abroad. And so all of these things have the end result of enabling them to get access to data, but at the cost of diminishing our privacy expectations and making us less secure in how we communicate online. Because if you think about it, just real quick, if you think about it, if the NSA wants a backdoor so they can get access to certain forms of data, well, that backdoor exists for everybody. It exists for the NSA. It exists for identity thieves. It exists for people who want to use, steal our money from our banks or whatever it may be. There's no way to create a government-only backdoor, and that's the real problem.
That's the problem. The people who stole all those credit card numbers from Target can go in that back door too. Is that what you're talking about?
Basically, yes.
Okay. So did he say anything about this?
He said absolutely nothing about it. And this is something that technologists are really worried about, this idea that the NSA and the government have been basically watering down some of the technical safeguards we have. We've talked a lot about these NSA programs. We talk about how they violate our legal safeguards and our legal rights. But it's also a matter of violating some of these technical safeguards that are put in place to protect us and protect the sanctity of sensitive information that's transmitted online. And that's the real issue. And I forgot to even mention that one of the other parts of the NSA's approach to watering down the security is there's a report again that in Der Spiegel, the German paper, that basically the NSA was even intercepting hardware, basically intercepting packages that may contain computers or a memory card or a USB drive or hard drives, and installing backdoors into that before allowing the package to be delivered to its final destination. And it's these types of practices that really are very, very worrisome to anybody who values the privacy that technology can enable.
So what should he have said on this? What's the fix for this? They just need to stop watering down internet security to make it convenient for themselves?
Absolutely. He should have said something to the effect of, to the extent that the government is lowering the encryption standards or lowering, installing backdoors, we're not going to do this. We're not going to jeopardize the security of everybody on the web, both here and abroad, and so that the NSA and other agencies can get access to information they're not otherwise entitled to access. That's what he should have said. He didn't say it, and he got a 0 as a result.
Okay. Are the encryption standards, is it theoretically possible to encrypt something that the NSA can't break into?
Well, I mean, that was always the hope, and to be fair, they employ some very good
They're very good at what they do.
computer scientists and
that.
engineers and mathematicians whose job it is to break these standards, to break the encryption and get the information out. And so there's this ongoing tension where you'll have one group of highly educated, brilliant mathematicians who are working hard to increase the the protection that encryption affords, and on the other hand, you have another group of highly educated, intelligent, hardworking mathematicians who work for the NSA and work for the government, who are trying to kind of counteract what the other side is doing. And ultimately, I hope that the good guys, if you will, win, and that we can have strong privacy safeguards for everyone. But in the meantime, as this kind of game, this tension is being played out, the losers become us.
Yeah. Well put. What else do we look at on the scorecard? Reject the third-party doctrine. This is an interesting one. Explain the third-party doctrine.
Sure.
We've been through it on this program, but I think it's important to go over it.
Sure, and so the best way to talk about it is to kind of, we have to back up a little bit, start at the beginning. And basically, when we first started talking, I mentioned the right to be free from unreasonable search and seizure. That comes out of the Fourth Amendment to the U.S. Constitution. And what the Fourth Amendment ultimately says is, we all have the right to be free from unreasonable search and seizure. And what the courts have basically interpreted that to mean is that the government needs a search warrant in order to basically search a person, their papers, and their effects. Now, the word search has a very particular and probably peculiar legal definition. And to search really means for the government to basically intrude on a person's expectation of privacy. And in a sense, it really encompasses two important things. First, a person must have a subjective expectation of privacy. And second, that expectation of privacy has to be something that society would treat as reasonable. So for example, you've got a backpack down here, and you subjectively expect that I'm not going to look through your backpack, which is, I think, most people in the audience would treat as reasonable. So if I were so if I were to do that, then I've engaged in a search under the Fourth Amendment. And if the police or the government does that, they generally need a search warrant.
Okay.
Now, what the third-party doctrine says, and it's basically a doctrine that comes out of two Supreme Court cases from the 1970s. What the
1970s.
From the 1970s. What the third-party doctrine says is that when you expose a piece of information to someone else, you've surrendered your expectation of privacy in that information. And the thinking goes that if I tell you something, I forever lose the right to claim that item that I've just told you is secret, because I run the risk that you can go and tell it to someone else. So any information that is exposed to someone else loses its expectation of privacy under the third-party doctrine. Now, as a result, what's happened is that doctrine has been used to basically defeat Fourth Amendment challenges by finding that there's no expectation of privacy in information like the phone numbers you dial, the phone numbers that dial you. And in the NSA context, that is how the government can justify obtaining everyone's phone call records without a search warrant, because they say you don't have an expectation of privacy in that information because that's data that you've turned over to the cell phone company. You've turned it over
by dialing somebody's number.
Exactly. And as a result, there is no warrant requirement. So that's the third-party doctrine. And what we wanted to see President Obama do is to really address this doctrine, because that's the legal underpinnings of the whole surveillance programs with respect to the NSA. But it even goes broader beyond that, because we're seeing today that law enforcement can get access, are trying to get access to people's Facebook accounts, to get access to cell phone records that reveal their location, if by, for example, a record of which cell phone towers a person connects to when they're making a phone call. And the third-party doctrine has repeatedly been used to defeat Fourth Amendment challenges and allow the government to get warrantless access into these types of information.
This is the doctrine that Justice Sotomayor referred to, I think, and said this needs to be revisited, right?
Absolutely.
You said 1970s.
Right.
This is before even the personal computer boom, let alone the internet, let alone smartphones and everything that we're carrying around with us.
Absolutely.
What would be the new standard that would recognize the new technologies?
Well, I think there's a misconception sometimes that says that there needs to be a new standard. I actually don't think there needs to be a new standard.
Okay.
And that's because the court has actually consistently held that you don't surrender your expectation of privacy and information turned over to third parties in other contexts. For example, In 2000, the Supreme Court issued a case called Bond, which involved a passenger on like a Greyhound bus. And basically what happened in that case is he put his luggage in the overhead bin of the bus, and a police officer, an immigrations officer, came on the bus to do an immigration check, and he basically touched the person's bag without any suspicion, without a search warrant. And the Supreme Court said that was unreasonable, because even though you put your luggage on a bus with other passengers, you don't expect someone to go through and touch the bag, let alone go inside the bag and search it. Just even touching it and feeling for certain items you wouldn't expect. You may expect someone to shift it over to fit their bag in, but you wouldn't expect someone to completely manipulate and really feel the bag in that sort of way. And so we're not even talking about creating a new doctrine, but rather just recognizing that it's not an all or nothing game, that it's not a zero-sum solution. But I think even more, if you think about the technology issues, I think the way to think about it is courts have to realize that even if you expose discrete bits of information for limited periods of time, we very rarely expose or disclose huge amounts of aggregated, rich, detailed information to anyone. So for example, you mentioned Justice Sotomayor. Her case, the case she wrote that opinion in, was a case that involved GPS tracking, right? And in that case, the issue was the police had used a GPS device to track a car for 28 days in public roads. And the question is, well, do you expose yourself in public on the street? Absolutely. If I'm driving down the street, I'm exposing my location to the car next to me. But I don't necessarily assume that person's going to then follow me for a month.
For 24 hours for a month. Yeah.
Exactly. And it's the same sort of thing, that just because you expose a discrete bit of information like one phone number you dialed over one day doesn't mean you authorize the disclosure of all of your call records of all the time for time immemorial. And I think courts have to start thinking about this issue more realistically and understanding that kind of bulk collection of aggregated information reveals a whole lot more than just one discrete phone call or one discrete drive down the street.
Or even a whole mess of discrete phone calls, because this data can be analyzed to actually track a person, find out a whole lot about their lives.
Well, that's why the government, and that's exactly why the government
why they want
wants
it. Yeah,
absolutely.
Yeah. Well, they're not dumb. That's the problem. So let's look at a couple more, and then we'll get to the audience and get them in on this conversation. There's a couple you said that really kind of go together. Provide public accounting of spying programs, which he got half a point on. That's his best score on the card. And embrace meaningful transparency reform, and he got a 0 on that. So public accounting, but more transparency. We've got a little bit of public accounting with the release of these records requests,
right.
But not much transparency.
Not much at all.
What was EFF looking for here?
Well, we were looking at a couple of different things. With respect to the accountability, we're really looking to see, is Congress being kept in the loop about what's going on and how these programs are being used? In the aftermath of the Snowden revelations, there was a number of members of Congress who said, this is not what we had in mind. We did not realize that this was what was going on. We are, and asking difficult questions about these programs. So I think that's one component of it. Another component of it is in criminal cases where this evidence has been used, there hasn't necessarily been full disclosure to criminal defendants that, hey, surveillance under one of these programs is being used against you in your case, and only now that's starting to happen, and that's happening even in cases where the defendant's already been convicted after trial.
Yeah, there's something going on right now that I was just reading about where there have been 2 defendants notified that part of the evidence against them comes through one of these NSA programs. And that's something that came out of the Supreme Court, and it's just starting. So how will that change things? Will that give us a deeper look into these NSA programs? Will it provide a courtroom arena to really examine what's going on here.
I think it will provide a courtroom arena to examine what's going on. I don't know if it would necessarily give us a whole ton of rich detail in terms of the public interest, but at least with respect to specific defendants who are facing, significant prison time and significant consequences for the charges the government has levied against them, it allows them an opportunity to contest the validity of these programs, which is an important component to any sort of accountability, meaning having a chance for the courts to weigh in on what is and isn't permissible. So I think that's another important aspect of the accountability. When it comes to the transparency, we've seen a lot of obstacles in place by the government to kind of block what's going on. We've already talked a little bit about how they've tried to prohibit the companies from disclosing the specific numbers of requests they've received. Another big problem is, the FISA court, and the FISA, to be clear, is the Foreign Intelligence Surveillance Act, which is the law that governs a lot of this national security apparatus. There's a FISA court that basically authorizes some of these specific collection programs, and many of the decisions of the FISA court, which is a judicial court made up of federal judges appointed by the Chief Justice of the U.S. Supreme Court, many of these FISA decisions are never declassified and they're never revealed to the public. So we've got a secret court making secret law when we think we live in a democracy where the law is transparent and accessible to everyone. We may disagree with the legal decisions, we may not like the law, but at least we know what it is and we can review it and research it and try to challenge it. But instead what we have is a secret law being made in a secret court in secret cases, and that's absolutely the exact opposite of what is and isn't, of transparency in the court system. And so that's what we are really concerned with.
I do want to get to our audience questions, but since you brought up the FISA court, one of the things that Obama did mention in this speech was exploring the possibility of having some kind of third-party privacy advocate or panel actually to be there at the FISA court and challenge some of this, because our court system, our justice system, is supposed to be an adversary system. You have, a prosecutor and a defense attorney.
Right.
And in the FISA court, there's no defense attorney for the people. What's your take on that?
Well, I think it's an important first step. I was previously a public defender. I know exactly how important it is to have someone there to counteract the government, to be the voice of the other side to the court who has to make an important decision. And so right now, the FISA court as constructed really is what we call an ex parte proceeding. It's a one-sided proceeding where the judge hears what the government side is and then hears nothing else and then has to make a decision. So one of the reforms that's been floated is to have some sort of privacy advocate or a public advocate who would basically represent the other side, because obviously we can't tell the suspect that they're going to be under surveillance and bring their attorney to court to challenge that, but instead to have someone who could handle bring up the public policy and the public interest in privacy to the attention of the FISA judges. And so that's something that President Obama said he was interested in looking into, and there's been some legislative proposals to do that, and I think that would be a very good thing. It would be a very good step in ensuring that the court, before issuing a decision that authorizes the bulk warrantless collection of sensitive records, is hearing from the other side and is thinking about the privacy aspect of this as well.
Yeah, because I think one of the problems right now is the government can go to the FISA court and say, well, we have a suspicion of this person doing this, and there's no challenge to that. They can just, that's how Verizon turned over all their records. All right, I've gone too long. Let's go to the audience. I'm sure there's a lot of questions out there. Crystal will be bringing a microphone around so people can hear you at home. So if you'll raise your hand, and if you'll also stand up to ask your question if it's not too much trouble for you, that makes it easier on our camera folks. And we'll go there next. And hold the mic right up to your voice.
Thank you. Thank you.
It's on.
It's on?
Yeah.
This is a wonderful discussion. You mentioned the metadata program allows them to find out who you called, why you called, and how long you were with them. If they're not looking at content, why do they need encryption? I'm assuming you don't need encryption just to find out telephone numbers being called, right?
Well, so it's important to keep, there are a couple different things going on here. So the first is there's the phone collection program where they're collecting the phone metadata. Another part of this NSA surveillance apparatus, if you will, is the collection of internet records and internet metadata. So that could be, who you email, which websites you visit. Now, some of that information can be protected through the use of encryption, meaning when I send a request, if I'm using, if my browser is configured to automatically, by default, communicate with websites in an encrypted way, meaning when I type in www.facebook.com, it's sending that request in an encrypted format, or if I'm logging into my bank and I'm putting in, you log into Wells Fargo, for example, and you put in your username and password, and that information is being transmitted in an encrypted form, that is helping to keep your information sensitive and private. Now, the encryption doesn't necessarily speak to the phone metadata program, but it does speak to the internet metadata program. And it also speaks to the fact that in order to get some of this internet metadata, particularly some of the internet metadata that's stored overseas or that's transiting from overseas, the government has tried to water down some of the encryption standards, and they've tried to break encryption so that they can get access to that information, like who you're communicating with online, or theoretically your bank username and password, even though that may not be the sort of information they're looking for. But that's how the encryption comes into that.
Thank you.
Sure.
Okay, and then Crystal, there's one here in the second row. And I will, okay.
Hi, Hanni. Thanks for being here, and thanks for the work.
Thank you.
In October of last year, Apple released a new OS 10 upgrade called 10.9 Mavericks, and we all lost a capability that we had prior to that release, the ability to synchronize our contacts and calendar entries on our local computer.
Mm-hmm.
Now, every time I make a calendar entry or a new contact entry, we have a time factor of roughly 10 seconds before that information appears on the remote server, and I can see it in my web browser, and presumably so can others. Just interested in your reaction to that, and have I surrendered my expectation of privacy under the third-party concept?
So that's a great question. Actually, that's something that
Yeah.
EFF is really concerned with. I'll give you full disclosure. EFF, most of the lawyers, we use Apple computers. They're great computers. A lot of our staff have not updated and have not upgraded, including myself, have not upgraded to Mavericks precisely because of that problem. And you're absolutely right. Once the way the legal doctrine works is that once you turn the information over to the third party, whoever that third party may be, Apple, Google, Facebook, it doesn't matter. Once you turn that data over to a third party, you've surrendered your expectation of privacy in that information. And so that's another part of the problem here is that you may have a calendar and you may be syncing it to a cloud-based calendar like iCloud, for example, to use the Apple program, but you don't necessarily intend to share that with everyone. It's your personal calendar, just Apple is holding it for you. But yet the courts haven't really caught up to that. There are some cracks in the doctrine. I don't want to make it sound all doom and gloom. There are some cracks in the doctrine. A great example is email, the actual contents of your email. The courts have started to say that, the contents of an email message you send, even though it's held by someone else, like if you send a message from a Gmail user if you're a Gmail user and you send a message to a Yahoo user, Yahoo is the one who holds the message, right? As long as it's sitting on the server. Courts are starting to say, that email message, at least the body of the message, is still protected. You still have an expectation of privacy in that. Because just like you send a letter in the mail, you write a letter, you put it in an envelope, you seal the envelope. When you give it to the postman or you give it to the post office, you don't expect the post office to rip open the envelope and pull out the letter. You still have a right of privacy in the contents of your letter. You may not have a right of privacy in the name on the outside of the envelope or the address or the stamp, But in the terms, with respect to the contents of the letter, you absolutely have a right of privacy. Should be the same thing when it comes to emails. Now the issue is, how can we get the courts to say it's not just the contents of the emails, but it's everything else too? And that's really one of the battles that EFF is fighting to this day.
So you're not recommending switching over to PCs. Stay with Apple, but don't upgrade.
Well, I don't want to. I don't want to say we're
get you.
sponsored anything, but I mean, your concern is a really good one, and it's one that we share too.
This is non-commercial television, so we won't do any endorsement. Do we have another hand out there in the audience? Okay, up front here, and if you'll stand up, please.
Is it possible to research an article on terrorism without becoming immediately a suspect?
That's that's a great question in the sense that it really gets at some of the problem, right? Which is, look, everybody here wants the world to be a safe place. I don't want terrorist attacks happening in this country at all. But the issue becomes, when do we let our fear of stopping that sort of violence overtake some of the civil liberties we cherish that make this country worth defending in the first place, right? And I think that's really where there's some tension here, where we have these surveillance programs that are designed to keep us safe, which I'm all for keeping us safe, but at the same time, we have to make sure we don't betray our values. And these programs, I think, way too far on the side of security at the expense of privacy. And part of what I think EFF is trying to do is to recalibrate it and bring the balance better in the middle. We understand that there are going to be times where the government is going to be allowed to intrude on a person's expectation of privacy. But that should come when they've got real, particularized, probable cause that someone is engaged in criminal activity, engaged in terrorist activity, is a threat to national security. At that point, that's when the government should be allowed in. But to collect everyone's records and kind of say, well, everyone is a suspect in a sense, is, I think, going too far.
What do we know about what they're doing about search? Is that shown up in any of the Snowden documents? Any search, when people, like his question, if you do a search on terrorism, is that part of the data that's being collected? Is that, the Silicon Valley companies that just released said we got 59,000 requests. Do we know, is that part of what Google is being asked to turn over what people are searching for?
I don't know definitively, but I would imagine it is. And the reason I would imagine it is because outside of the national security context, in your typical garden variety criminal case, you will oftentimes see, and I've personally seen this, where prosecutors are going to want to introduce evidence of a person's web search history in order to prove that they've got the guilty mind. So I'll give you a great example of this. If you remember the Casey Anthony trial, this was the young woman in Florida who was accused of murdering her little baby. And part of the government's evidence in that case was to introduce evidence of what she was searching for online. Search terms like, that suggested that she had a mindset towards harming her child. So if we're seeing this being done by local county prosecutors in routine criminal cases, you can bet that the NSA has this sort of capability, and so it wouldn't surprise me. Now, what those specific keywords are or what they're looking for, I'm not really sure, but I would imagine that if someone Googled how to build an explosive device, there's going to be some focus and attention put on that person, and that's again part of the problem. Like you can Google that because you're an academic researcher and you're curious to see what shows up and you want to write a paper about it. You can also do that because you're a deranged lunatic and you want to kill some people. And it's hard to differentiate between the two if you look solely at what the person is doing online. And so that's again some of the problem with this. How do we balance these kind of oftentimes thought of competing interests of security and privacy, of being allowed to exercise your right to freedom of speech, at the same time making sure we don't have terrorist attacks every single day.
The problem seems to be that the default assumption of the government is that we're all deranged individuals seeking to do harm. And maybe we are, I don't know. Any more questions out here? Let's, feel free to throw up a hand anytime that you feel. I'll keep an eye on you out there, along with the NSA. Yeah, let me come back for a sec. Let's, in about the 10 minutes we have left, let's talk about some of the pushback and what we as individuals and collectively as activists need to do. And then you've got some lawsuits going that are pretty interesting. Let's talk about those briefly.
So I think the first thing that people have, I think there are a couple things that people individually have to do, and then we can talk more specifically about what EFF is doing. I think the most important thing is people have to be aware of what's going on. And I think the fact you're all here today is a good sign that you guys are aware and that you care.
That's
about
why we're
what's
doing
going
the
on.
program.
Exactly. But I think even beyond that is it's important to start to take control of your online presence and your online life and take the technical steps to protect your data, to protect your privacy that are available out there. So I mentioned encryption, and I mentioned that it's an important safeguard. Well, one of the things that EFF has done is we've developed some software. It's called HTTPS Everywhere. And what HTTPS Everywhere does is it's installed in your web browser, and it basically makes sure that when you search the web, your default search is encrypted. And it forces encryption, make sure that your searches or anything you're doing online is encrypted. That's a great way, and it's free. You can download it if you use.
And that's at EFF.org.
If you go to EFF.org and you look for HTTPS Everywhere, it takes 1 second to install it, and you're already taking a step to control, take some control over the sanctity or the privacy of your web searching history. So that's some of the technical steps you can do. And then obviously, there's in this growing outcry, there are a number of ways to get involved, write your legislature and that sort of thing. And we have action alerts on our website where where we talk about certain pieces of legislation we like and legislation we don't like. I think it's really important that we let, our lawmakers know that we're unhappy with what's going on. I think lawmakers many lawmakers, not all, but many lawmakers are starting to realize that there is a widespread public outcry about this. As you mentioned, that's why President Obama even gave this speech in any event.
Yeah.
And I think that more pressure is going to help us get more changes. Then with respect,
our own Senator Dianne Feinstein, though, doesn't seem to be hearing that message.
well, she unfortunately is a very big defender of some of these NSA programs. She's not, she hasn't necessarily seen or recognized some of the concerns about the programs, and it's disappointing. You would think that the senator from California, which is where many of these big technology companies are, that's pretty values its privacy, has traditionally been ahead of the game on privacy. We mentioned the third-party doctrine. I should quick tangent. The California Supreme Court rejected the third-party doctrine in the 1970s. There is no third-party doctrine under California state law because the California Supreme Court said the records of who you call are absolutely private and important, and they reveal so much about you. We're going to provide constitutional protection under our state constitution. So it's disappointing to see the senator not necessarily coming to the same conclusion, even though in California we've got a traditionally very strong history of privacy protection. So it's disappointing, but my hope is that she's just 1 out of 100, and there are a number of other senators and there are a number of other members in the House of Representatives. There's a push in the state legislature to kind of see if there's anything they can do to kind of curb some of this. And then one last.
What's the best thing in Congress right now that we should be looking at and supporting?
Well, Senator Leahy from Vermont has a bill. The name escapes me of the bill, but basically it's an overhaul of much of FISA. It includes some of this public advocate in the FISA court. It would end 215 bulk collection of phone metadata records. So that's, I think, a better approach than some of the legislation that Senator Feinstein has introduced. So Senator Leahy
These
has
seem
that
to be
bill.
the two main competing bills.
Yes,
Feinstein's FISA Reform Act, so it put reform in scare quotes, and Leahy's bill.
Yeah, absolutely.
Okay. Just a few more minutes. EFF has, you brought a lawsuit when one of the first things that was revealed by Edward Snowden was a FISA court order to Verizon to turn over all the records. And suddenly you had a lot of possible defendants who could say, the government is getting our stuff. One of the problems, as I understand, in trying to challenge any of these laws is that people who are going to the courts about this can't prove that they're targets of the surveillance, right?
Right.
So now you had some proof. We've got about 3 minutes left in the program, so
Sure.
explain this.
Sure. So EFF has basically, we have two lawsuits. One that we filed back in 2006, and I'm sorry, 2008, and one that we filed more recently. The one that was filed in 2008 came after the New York Times and the USA Today revealed that there was a massive warrantless wiretapping program instituted by President Bush, and under that program, at AT&T's facilities in San Francisco, there was basically a program in place that involved what we call the splitter, where basically all of the internet traffic that was coming through AT&T's cables, the NSA was basically getting a complete copy of all of this data before the data reached its intended recipient. And
This
we've
is
sued
the one
over
where
that.
the guy who actually installed the wires
Yes.
testified about it.
Absolutely.
When-
An AT&T employee who was responsible for this came over to our offices and said, "I've got something to show you." And the result was we've sued them, and that case is still being litigated. The more recent lawsuit that came out of the Snowden disclosures was our lawsuit that challenged the phone records metadata collection program. And what we've done is we've brought actually a First Amendment challenge as well as a Fourth Amendment challenge. And what we have is our lawsuit involves over 20 different plaintiffs that include organizations like Greenpeace as well as the Council on American Islamic Relations, some gun clubs, churches, religious groups, you name it, whole groups of associations who feel that the phone records program violates their First Amendment right to association because it really puts a pall over you and really would cause you to kind of chill your speech if you think that the government is watching who you're talking to, especially when you're dealing with politically sensitive issues or religious issues, etc. And again, that case is ongoing. They're both filed in federal court in San Francisco, and they move along slowly, but we're hopeful that the courts will see it the way we see it and declare the programs unconstitutional.
Yeah, when the Verizon case was being put together, I actually got a call at the Peace and Justice Center
very good.
wondering if we had Verizon as our phone provider. And when I learned what the case was about, I said, "We don't, but I'll change." But that one seems to have a really good chance of getting somewhere since you do have the standing, right?
I'm hopeful. I mean, the standing has always been a challenge. Another doctrine that's been used as a challenge is called the state secrets privilege. That basically says the government can't disclose any information that would be necessary to litigate the lawsuit because it would pose a threat to national security. But given the Snowden disclosures and the widespread discussion about this in the public and President Obama's
We got to let it go there.
Exactly.
My guest has been Hanni Fakhoury, staff attorney for the Electronic Frontier Foundation. You've been watching Other Voices, brought to you by Peninsula Peace and Justice Center. Next month, we're going to be talking about the Trans-Pacific Partnership, or the Corporation Freedom Act of 2014. Hanni, thanks for joining us.
Thanks so much for having me.
Okay. Thank you all for coming, and thank you all at home for watching.